So we will, I guess, look to move forward with the agenda. It's 6:32, so we'll call this meeting to order. First item on the agenda is the approval of the agenda. I'm not allowed to make motions, but I do want to put this out there, and perhaps Mr. Mendez can take it up. But the hearing procedures discussion and the discussion of the bylaws, I believe that they may be resolved under the same discussion. So I don't know if we perhaps would want to combine the two of those. And I believe that given the other opportunities for public comment, that the number 10 after that public comment may not be necessary as well. But again, I can't make any motions to that, but just wanted to point those things out.
Okay, let me take a look here.
Bellamy, can I get a clarification? Are you saying that the number 10 item for public comment after our discussion would not be necessary? Are you saying that maybe move number 7 to after those two item discussions?
Well, I think
to have two separate.
Well, I think ultimately number 10 won't be needed at all. And I think the update that I believe Mr. Mendez will provide will combine items 8 and 9. So conceivably the last public comment would take place before the update Mr. Mendez would provide. And then from there, it would basically adjourn the meeting.
Let me get to just a second.
Sure. And this is because of, some recent updates that have taken place prior to when we put out the agenda.
Okay, let's see. Here I am. Yeah, I think it would be very reasonable. So I move that we combine items 8 and 9 in the agenda.
And is there a second for that? Did you want to leave in the public comment subsequent to that, or eliminate that as
well? Yeah, I see no reason to take out the public comments.
Okay, very well.
More the merrier. So
we'll have the update, a public comment period. Obviously, what information will be presented by you on the combination of 8 and 9, and then another public comment period after that.
So moved. Yes.
Okay, very well. Is
Second.
There okay? Ms. Robinson, do you want to poll the audience? I mean, the board.
Sure. Mr. Brown?
Yes.
Ms. Carpenter?
Yes.
Dr. Frazier?
Yes.
And Mr. Mendez?
Yes.
Okay, so that passes. So the next item on the agenda is the adoption of minutes. I didn't see any changes that needed to be made from my end. I don't know if anybody else.
I move that we adopt them as written.
Is there a second?
I'll second that, Bellamy.
Okay. Ms. Robinson?
Mm-hmm. Mr. Brown?
Yes.
Ms. Carpenter?
Yes.
Dr. Frazier?
Yes.
Mr. Mendez?
Yes.
Very well. That passes. Let's do this here. Mr. Wheeler, we're now at the public comment section. If you wanted to.
Thank you, Mr. Chairman. We have 5 people in the audience. If you'd like to address the Police Civilian Review Board, please click the raise hand icon in the Zoom webinar. If you're watching via Facebook or Boxcast, you need to join the Zoom webinar at charlottesville.gov/Zoom. If you register, you can get into the meeting that way and join us and raise your hand. We have one person who's got his hand up right now. It's Jeff Fogel. I'm going to keep time on my phone. Mr. Fogel, you're on with the PCRB. You've got 3 minutes.
I had the occasion to have lunch with Phil C. And to talk to him about the letter that he wrote to you all and to the council. And what disturbed me about our conversation was how little Philip knew about how bad the actual operation of internal affairs is right now. And so I'd like to share with you some of my experiences with internal affairs, which I hope some of you may know already, but I think it's important that this be available. And I'm going to rely on cases that I have prosecuted through internal affairs on behalf of cases that will not come before you. So let me start with one case where I had a rare instance of a citizen's complaint sustained, LaQuinn Gilmore. So we were contacted by internal affairs to come and speak to them. And when we got there, we were told by internal affairs that they were going to video the interview. And was that okay? And I said, sure, as long as we can have a copy. And they said, of course you can have a copy. It would be natural. So we proceeded to the interview and they were able to ask LaQuinn any questions they want. I never got that, what was promised to me. When I pursued it, I was told that, the city attorney somehow had ordered the police department to renege on that agreement. And it never should have been made in the first place. We then asked for the names of the other officers who appeared at the scene. The Internal Affairs refused to provide it. We asked if we could do a lineup so that my client could pick them out of a book, out of their photograph. We were told you couldn't do that. We asked to see the body cam footage of precisely what happened. And we were told that we couldn't see that. Now, somehow we prevailed. And the reason that we prevailed in this case was because there was body cam footage which definitively showed that the police officer was wrong, seriously wrong. And as a result, as you may know, he got fired, and that's the right thing. But the process is one that is not welcoming to complainants. In fact, after the process was over, that very video, well, we wanted to see all the videos, but there was only one ultimately shown after the case was over by the police chief. And in it, she took the occasion to point out any discrepancy that the police department could find in not the report of the police officer, but in the report of the complainant. So, for example, Mr. LaQuinn believed that his taillight had been knocked out and done by the officer who had assaulted him. Well, it turns out that didn't happen. And in fact, the police chief showed a picture with diagrams and arrows to show that they were not that they were broken before the confrontation. Well, that was true, but LaQuinn didn't know that because it happened with his sister. But the police department never came back and asked, Mr. Gilmore, we have this, what do you say? No, we don't get to see videos. We don't get anything. I just want you to understand how uncomfortable it is for complainants to go to the police department. And I'm hoping for the Lord that you will have the authority and the gumption to change that process and to make it a welcoming process for citizens.
Mr. Fogel.
I'm sorry.
Thank you for your comment. Mr. Wheeler, are there any?
We do have another hand raised. Next up is Katrina Turner. You're on with the PCRB and you have 3 minutes.
Hello?
Can you hear us?
Yes.
Yep, go ahead, Katrina.
I'm calling, I'm wanted to talk also about my case, which is well over 5 years old. But everything that has happened in my case now it's in human rights hands. Way back then, I wish there was a strong CRB who could have looked at my case, because there are so many violations just from the decision letter from the police department. There are so many violations against the police department, but nobody ever reviewed my case the way they were supposed to have reviewed my case. Because, see, my case dealt with an officer who had a father as a chief of police at the time that he assaulted my son. I've said for over 5 years, and I'm going to continue to say it, that the police department changed records in my complaint. And I have called the police department out for over 5 years. Not one time have they come after me and told me I am lying about what I'm saying. Okay. There's complaints that were filed against the police chief of police. I asked to speak to the special investigator who took care of that complaint. I never got to speak to the special investigator. Everything that I asked that I rightfully had a right to see, or anything that I had a right to get, I was denied anything in this case. And I think that having a strong CRB will help people like me, to, when we file complaints, we would like to know that they are taken care of properly. But I think it's a shame that all these years later, that now, 5.5 years later, my case is in human rights hands. So what I would like to ask you all, with my case being in human rights hands, would I have a right to bring it forth to you to see if you can look over my complaint? So thank you for allowing me to speak.
Thank you, Ms. Turner.
And one last call for any hands to be raised. I don't see any additional hands.
Very well, thank you, Mr. Wheeler. Next item on the agenda is the status of the complaints. This has been sent out to the board, as well as posted on the PCRB's website, obviously with redacted information. Currently, there have been 13 reported cases that have crossed our tracking. Obviously, there, what do we have? For the total this year, there are 21 cases. So the other 7 would be ones that, as is presented to us, have elected not to have them forwarded to us. The 13 that have been reported, 10 are closed, 3 are open. From the last meeting, the types of 2 came in. The types of complaints were professionalism, reported by an African-American female, and rudeness, disrespect, intimidation during arrest of and detention of Spanish-speaking resident was reported by Latin or Hispanic female. And so those are the updates with regard to case tracking right now. Are there any questions or comments? Okay. Next on the agenda is the update on the executive director process. And before that, before we turn this over to Vice Chair Mendez, I am disqualifying myself from participation in any board discussions or actions relating to the city's recruitment of the executive director. Because I have applied to be employed in that position, I have filed a written disclosure statement with the clerk of council. And that statement is available to the public upon request from Ms. Robinson or Ms. Thomas. At this time, I turn over the gavel to the vice chair until the board's discussion of the recruitment process is finished, and I ask that the minutes of this meeting reflect my verbal disclosure.
Thank you, Bellamy. Actually, I think I'm going to turn it over to Dr. Frazier, who will give us his insights on the interview process as he has experienced it.
Thank you, Mr. Vice Chairman. Quick update, no specifics. We are in the throes of interviewing. We hope to have some recommendations to the city manager within sometime in July. But at this point, I can't speak to any specifics except we are interviewing 8 candidates, which was who were chosen from a much larger pool, 8 highly qualified candidates, and we're in the middle of that process. So I will leave it at that.
Well,
I do have a question.
Yeah.
Yes, Ms. Carpenter.
Thank you. Did I understand the process correctly that once I think that there will be some input from the board as a whole on the candidates, the final candidate or the final candidates at some point in the next few weeks, or is that wholly within the purview of you folks that were volunteered or who volunteered to?
No, the final,
interview?
Ms. Marshall can correct me on this, but I think the final round involves, Ms. Marshall, is it everyone except Mr. Brown who's taken himself out of this process in that final round? Did we lose Ms. Marshall? There she is. She's muted.
Yeah, as I understand it, in the next round of interviews, there will be 2 volunteer participants from the CRB. And then in a final round, all 3 of the participants will be involved with the city manager's representative in a closed meeting, because that will be considered a personnel issue. So yeah, input there.
Correct.
And also, Jeff, if I can ask one more
Yes.
thing, I know we've spoken about this. You gave me a quite favorable impression of the people that were interviewed.
Yes. I was struck with the quality of the applicants. I think the city manager, assistant city manager did a phenomenal job of narrowing the pool to 8 highly qualified people, and suffice to say it will be a tough decision and a close call when we get down to the wire.
Any more? Has the next round been scheduled yet?
I think that is in the works. Again, I would defer to Ms. Marshall if she's there. I was involved in the first round, and I'm not involved in the second round. So I'm not sure where that stands at this point.
Okay.
I think there's something tentatively scheduled for next week, but I think it's there are 2 other board members that are participating in that, and I'm not one of them, so I'm not in the loop on that.
And they're not attending tonight. So
correct. It's Ms. Gilmore and Mr. Watson.
okay. That sounds very very hopeful. Are there any more questions regarding the executive director search? Okay, I think that finishes this item. Turn it back to you, Chair Brown.
Very well. Thank you, Mr. Mendez. Next item on the agenda, we return to public comment. Mr. Wheeler.
Thank you, Mr. Chairman. If you're in the audience, and we have 6 people right now, and you'd like to address the PCRB, please click the raise hand icon in the Zoom webinar. And I do not see any hands raised.
Very well. So the next item on the agenda is going to be the combined hearing procedures / ordinance bylaws, I guess, discussion / update. And I'll let Mr. Mendez go first and add anything if necessary.
Okay, thank you, Bellamy. And just to bring people up to speed, since our last meeting, we have been engaged in spirited conversations with Councilor Snook and other members of the board regarding particular aspects of potential oversight models. Also, we are currently seeking another conference call with Chief Brackney. We have not arranged that yet. It will probably not take place owing to vacations for the next couple of weeks. An important development on both the hearing procedures and the bylaws, the ordinance, is that under our expanded scope of work, we have engaged Cynthia Hudson to undertake the complicated process of redrafting these documents in response to public comments. And Bellamy and I have been in conversations with her as she undertakes this Herculean task. We have not, we're still in the very preliminary stages of generating a draft. At recommendation of council, we've maintained it, the discussions between Mr. Brown, myself, and council, so that we can maintain attorney-client privilege better than if we had discussed this entirely among ourselves. But that's in no way indicative of a desire to shut anyone out. And certainly, once we get a document that we're comfortable with, we will be more sharing it more widely with our stakeholders, with the board, and with the city council. In that regard, we've gotten a recommendation from our independent counsel, which I think we should entertain. And that is that when we decide to discuss these documents among ourselves, the whole board, that we do so at least for the first session in a closed session. That way she can continue to give us privileged advice, and that will we can basically sit down with our smart lawyer and plot deep strategy, and have a little bit more confidence that she can speak freely, and that we can speak freely as well. Ms. Hudson, do you want to say any more about that?
Thank you, Mr. Mendez. I echo your comments. I think we've advanced, I think, pretty nicely along the path to proposed amendments that the board would consider and tighten up, ask questions, seek advice, rationale for the choices made, and make sure that what comes out of this process is a true board effort with respect to the amended ordinance that would then be made available, as Bill said, to stakeholders, large community, and to the city council as a recommendation from this board. the work has been brisk, I think, and productive.
And you said that you could assist us with the mechanism of holding a closed session.
Yes, Freedom of Information Act would require that the board in an open session entertain and act upon a motion to convene in closed session pursuant to an expressly articulated exemption that allows a closed meeting under the Freedom of Information Act. At this time, unless other factors develop between now and when the board decides to do this, if you decide to do it, the exemption would very likely be the one to receive to consult with legal counsel regarding matters that require legal advice. And that certainly, in my estimation, would apply to this subject matter regarding these documents in the drafting stages that they are in, the choices that the board will need to make with respect to what it seeks to advance as amendments certainly lend themselves to legal justifications, both with respect to the application of the new statute, 9.1-601, and other matters that pertain to the civil rights of all persons involved.
Thank you. Mr. Wheeler, yeah, as I understand it, in the that basically when a board decides to go into a closed session, they actually go to a different platform for that. So, you know, it's basically we would convene a meeting and then say we would then vote to hold a closed meeting, and then we would go somewhere else. Is that
That's
how that
correct.
works?
Yep. Our practice throughout the pandemic has been to start a public Zoom meeting so that they can hear the motion as you're going into closed session. We leave the Zoom meeting running, put up a placeholder slide that says you're in a closed meeting, and then you would go to another Zoom meeting room to have that event. And Max Robinson can connect you with a Zoom account if you need that. And then my team is not aware of, you know, the location of that meeting, so you do that separately. And then we have you return to the original Zoom meeting to certify at the end.
Okay. Okay, so I think, as Ms. Hudson said, we're, you know, we're pretty close to having documents that are, you know, we definitely have documents that are worthy of discussion at this point. And I think within, you know, certainly within a few days, we might be in a position to schedule such a meeting. And unfortunately, I have a vacation coming up in a week and a half. But just as a suggestion, if maybe toward the end of next week, if that would be feasible for people, and assuming there is an opening in the municipal schedule, does that sound? If we were to do it, say, a week from tonight, would that be a hardship for anyone?
Let's have a little discussion on that before, Bill, because I have a question
Sure.
about speaking freely in public. I mean, I don't have any problem with, you know, I guess as you all know, with putting some things out there. I'm not afraid of speaking, you know, in the public. I'm just wondering if this information that Cynthia wants to provide for us is that sensitive, because I also have to remember that when we had the initial PCRB, I don't think they ever went in to a closed session when they were talking about, as they were having discussions about their initial ordinance that was presented to council a couple of years ago. So I'm kind of trying to figure out, you know, why we feel uncomfortable speaking, you know, speaking in public. I'm just wondering what the optics of that are, and, you know, how sensitive this information is. I mean, what are the implications if people hear what needs to be heard? I mean, what are our, what kind of things are we going to face pushback or blowback on?
Well, I don't think it's necessarily a thing of pushback or blowback. I think that there are certain aspects under which attorney-client privilege covers that would, that would prevent us from being exposed to any potential liability. And I think our legal counsel here, and she can elaborate more, is suggesting that some of the conversations that we may have around, the makeup of the ordinance or the makeup of the hearing procedures itself may in fact be privileged, and we need to. I mean, none of us have really sat down and talked, in depth about what's being presented. So anything that could come of that, if we were to just open it up to public view, could open us up to that liability that's not covered, or that is covered under attorney-client privilege. And I'll go ahead and defer to Ms. Hudson for more.
Certainly, Bellamy. And I'll let me say as an initial premise that there's not encouragement or a strong recommendation as such that this discussion of the draft or amendments to the ordinance that the board would propose, or of the hearing procedures that we've been working on, necessarily require a closed session. However, it will indeed, I would expect, generate a number of questions from board members that require legal advice or legal opinions about choices that the board might make in various provisions that it may wish to include, or various approaches to the exercise of authority that's been enabled by the recent legislation, even interpretation advice regarding the recent legislation and related statutes is all legal advice, which you're absolutely right, is not required as such to be discussed in closed session. But as Bellamy referred, those kinds of conversations that involve advice are typically privileged in nature. They're confidential client communications, unless you choose to bring in third parties, in which case you waive, or very well may waive, the ability to protect those communications in later controversies. So not so much that the conversation itself might create liability, but provides information that might be used against you later in some adversarial proceeding that right now doesn't presently exist. But the preservation of client confidentiality pursuant to the attorney-client privilege is something for the board to consider, but it's certainly not absolutely required. I thought that it was an appropriate conversation to have about the options that the board has about how to go about reviewing and finalizing these documents, so that, again, they are board documents and not just ones that have been worked on among myself, Mr. Bellamy, and Mr. Mendez. Clearly, they need to come before the board in some manner.
I'd like to.
Do you know what kind of legal liability you're talking? I mean, is there a better way to kind of hone in or give me some type of laser focus on, what kind of legal liability you're
Well,
no, once again, I'm not suggesting that there is legal liability inherent in having the discussion in open session. I just want to make sure that premise is accurately stated. The issue that was raised was that there will be advice necessarily shared or sought. Maybe if you do it in open session, the questions may be asked, but I would suggest that the answers may involve advice of a nature that should be communicated in an attorney-client privilege setting. It's always up to the client to decide whether to maintain or to preserve the attorney-client privilege. It's not the It's not the attorney's decision, but the manner in which having public legal advisory discussions may impact you in later controversies is, let me just give an example.
Okay.
Much of what the board will seek to do under the expanded authority that it seeks but doesn't presently have has to do with due process with respect to the property interests that police employees have in their employment by the city. There are all kinds of legal protections around the manner in which any public employee under certain conditions may be deprived of or that property interest, or how that property interest may be impaired. And to the extent there are discussions involving this ordinance that address the thinking and the legal thinking that goes into the provisions, there could be a suit later on by a police civilian or sworn employee who has been adversely affected by some action of the board, at least with respect to their employment, where they seek to allege that their civil rights were somehow violated, and perhaps that the infirmity or the reason for that goes back to the manner in which the ordinance was drafted, or a choice that was made in the ordinance that permitted the action that they say violated their rights. We would not be able to protect the conversation, the legal conversation around those choices, and that evidence would be evidence that certainly would be available unprivileged to be used against city interests, city government interests in that respect. And again, that's just an example of why you want to give some thought to whether or not some of the otherwise attorney-client privilege conversations should be had publicly. I'm not advocating that they be had in closed session, but it is incumbent upon me to advise my client as to what its options are in the protection of its interests.
Absolutely, and I appreciate that. I got into this public service work here with the PCRB, because I wanted to do it, in public, and so that's why I'm asking a lot of questions to understand why the public's work would be done, behind closed session. I mean, I haven't gotten any indication that there's any assumption that somebody, is ready to sue a PCRB or a civilian oversight board.
And that's not what I'm suggesting. And that's not at all what I'm suggesting. Attorneys play the long game, Ms. Carpenter. We try to.
Yeah, let me make a couple of observations here, if I can. First, the original board had an attorney on it. And I suppose that they felt that they could be self-sufficient in terms of anticipating the issues. The second is that with very little warning, as I understand it, and this is, someone may correct me on this, when push came to shove, when it came time for the city council to actually act on the 2019 ordinance, the most expensive lawyer in Charlottesville started showing up at all of their hearings and making it very clear that she was perfectly ready to sue on behalf of her client that was a police organization. And so this is the kind of situation that can arise. And I don't know, whether it's going to arise again and what the best way to defend ourselves against that is. But it does seem to me that, having one closed meeting is not a bad idea. I would not want to be in a situation where, as you say, a controversy on the board or a controversy with the kind of advice, kind of direction we gave to or got from our lawyer came back to bite us.
Are there any additional comments I'm sorry, Mr. Mendez, were you presenting a motion around that? I know Ms. Carpenter said,
Well, I have not presented a motion. I think what I was asking was to hear the sentiments of the board as to A, whether we needed a closed session, or B, whether we could do it a week from now. It does sound like there is a controversy here, and perhaps if we need to, we can defer that situation. But this is a time to GSD. We've been deferring this for so long that I mean, good Lord, folks. We're now into July.
Mr. Brown?
yes, Ms. Hudson.
I was just going to say that the manner in which it doesn't contemplate that you would agree in advance to a closed session. The idea of taking up a motion to go into closed session in a later meeting has to be voted on in the moment, and
Sure.
It depends on the outcome of the vote, as I'm sure you know. But I just wanted to make sure that that was on the record and appreciated. It's just a proposal, I would expect. Is that correct, Mr. Mendez?
Yeah, and I think that it may, as we move toward a draft document, we may feel more secure about our direction that we're going. We may feel less insecure about potential controversies that could come back and bite us. And so if we do have a special meeting sometime in early, relatively soon, we can at that time, if the majority of the board feels that way, vote to go into closed session. But we don't need to bind ourselves to do that now. So, Jeff?
I was just going to say, a week from tonight, I'm generally available next week. A week from tonight wouldn't work for me. Bill, I have a family birthday event that I feel compelled to attend, but I could do Monday or Wednesday evening or afternoon, just if we're going to try to arrange something.
I know that you'll want to have the closed session. I just want to say, I don't support going into closed session during the public's business, but the majority will have a consensus, and we'll do whatever the majority decides to do. I just think that we're just setting a bad tone by feeling like we can't talk freely because we're concerned about something that may never ever happen. And the fact that, some Albemarle County, City of Charlottesville attorney decided to show up at the, prior board's, initial board's meetings, I don't care. I mean, I want to do the public's business out in public because that's one of the problems that...
This was at the city council meetings.
Mm-hmm.
Yeah, so it was, she was influential in the city council, not the board, and that's the concern.
Influential is in the eye of the beholder.
Yeah. Well, look at the ordinance we have, and not just so Anyway,
I'm flexible with time, so either Monday or Wednesday would work, and I do believe that on the advice of our counsel that a closed session would be good. So I'm okay with that.
Likewise.
So if we, Nancy, could you make a meeting on Wednesday, and only if we are strongly in agreement that we want to go into closed session, will we do so?
Yeah, that's fine. I'm really flexible on evenings and such, so I wouldn't have any problem with that type of scheduling if we decide on next Wednesday or Thursday or whatever.
So
Well,
Mr. Wheeler, is there?
well, Mr.
Yeah,
Mendez,
go ahead.
Ms. Gilmore did show up, so we want to, I guess, get her input as well.
Oh, okay.
Ms. Gilmore?
Yes.
So we are having a discussion about, or a proposal to have a special meeting next Wednesday to review the draft ordinance and the hearing procedures that we've received from our legal counsel. Would you be available for that next Wednesday?
What time? Same time?
Dr. Frazier,
Same
Mr.
time,
Mendez?
yes.
Yes, ma'am. 6:30, it looks like.
Okay.
Okay. Go ahead, Mr. Mendez.
So, Mr. Wheeler, are the services available for 6:30 next Wednesday?
Communications can support a meeting on that evening, yes.
Okay. So I believe that the chair can, by himself, call a special meeting. So I don't think we need to vote on it.
I believe that it's 2. There has to
No,
be.
okay, all right.
Yeah.
Well, why don't we just vote on it anyway? I move that we hold a special meeting to discuss the ordinance and hearing procedures Wednesday, the whatever date.
14th.
Wednesday, the July 14th.
Is Ms. Hudson available that evening?
Am.
Okay. Critical piece. I second
Is
that.
there a second?
Second that.
Miss Robinson, could you pull the board?
Yes. Mr. Brown,
Yes.
Ms. Carpenter,
Yes.
Dr. Frazier,
Yes.
Ms. Gilmore,
Yes.
and Mr. Mendez.
Yes.
Okay. So that passes. So we'll have our special meeting July 14th at 6:30 p.m. to review the hearing procedures document and the ordinance draft. Mr. Mendez, was there anything else on that section?
No, is there anything you wanted to say about the hearing procedures that we need to know, or do you just want to wait till?
Well, so I will say that
Hudson Avenue.
from the hearing procedures perspective, it's a pretty, I guess, tight draft. I think there won't be many questions surrounding that, and we'll be able to. I mean, it's a lot shorter than the ordinance itself, but I think it definitely takes into consideration the comments by the People's Coalition, Mr. Fogel, and some other stakeholders in the community as well. And I think that we've been able to incorporate those pretty fairly throughout.
Now, Ms. Hudson, if we're going to hold a meeting, a special meeting next Wednesday to discuss the ordinance draft and the the hearing procedures have been out for comment, so the public has seen those. But
with one,
how do you recommend that we just? Yeah, go ahead.
Well, with one exception, so
how do you?
The latest version, the public hasn't seen that yet. But I guess the initial starting one they have seen, but the latest one that we'll be talking about, that hasn't been seen by the public yet.
So
Will that be
Ms.
on
Hudson,
the
I have the
website?
question.
Will that be on the website?
Go ahead.
That's a question that I was going to ask Nancy, in the sense that since we haven't distributed these to the public, how is the best way to distribute them among ourselves so that we will get a chance to review them? if there is this issue of, I guess the documents can be distributed, but then if we need to, our discussions can then be closed.
Yes, you can take up those logistical details with your staff support for the board in terms of you'll need to, of course, notice this meeting in accordance with the Freedom of Information Act, which for a special meeting requires that you give notice as soon as possible as the members have noticed that you're going to do a special meeting. And so you've just done that. So that needs to happen right away. And then in terms of any materials that are prepared for closed session, they may be provided to the board in whatever manner you normally would provide agenda materials, with the understanding that they will be designated as material for closed session. And obviously, board members are ethically inclined to maintain the confidentiality of matters and documents that are to be discussed in closed session. The law doesn't say that, but obviously you trust your colleagues to respect that. That's assuming that you go into closed session. Once again, the motion has to be taken up, and that may or
we
may
don't
not
know.
happen.
we don't know if we're doing it or not. So,
that's exactly right.
Yeah, so I think what we can, if we could, Ms. Hudson, I mean, I think we are, if I read correctly, we are very close to having sort of a consensus 3-person set of documents that we could send out that we believe are useful to send out. And so we can, when we've done that, we could just enclose them with our meeting packet.
Certainly, and I'm happy to discuss those logistics as you and the chair decide how you want to proceed.
Okay.
Together. You have a number of options, but again,
Okay.
It's hard to presuppose that you'll have the closed session, even though that may be your general consensus that we've got to wait on that motion.
Yeah, and Cynthia, thank you. I mean, I think I share your your desire to have things out in the open. I'm just a little bit paranoid maybe when it comes to what might go wrong. So
yeah, and I think you'll recall that what we've discussed is that the even greater heightened emphasis on transparency, which is at the core of the Freedom of Information Act. It's to be interpreted in favor of transparency wherever possible, which is why this is not a recommendation for closed session. It's simply a statement that it is an option, and there are perhaps reasons to invoke one, and whether or not you do is totally up to the board.
okay.
Are there any, sorry, go ahead, Mr. Mendez.
No, that's it. I have nothing more on this topic.
Okay. That being covered, Mr. Wheeler, would you poll the audience for a final public comment?
Thank you, Mr. Chairman. If you're in the audience, you'd like to address the board, please click the raise hand icon in the Zoom webinar. I'm going to keep track of time on my phone. First up is Harold Foley. Harold, you're on with the board and you've got 3 minutes.
Good afternoon, everyone. I missed some of the show, but I'm so glad Bill said that y'all had the GSD. Not only y'all, but City Council. And so one of the things I want to talk about is how I've been talking to the community about this issue of oversight. One of the things that has come to my attention that nationwide, there has been an uptick in violent crimes or gunshots or bullets being thrown in the air. And it's been hard to really have that conversation with people about police oversight. But I think what I come to the realization is about rules. Civilians break rules. police and authorities break rules, and both have to be accountable for their actions. But I want to make sure that they're accountable in a way where we're not just passing the buck and letting officers dictate how they're going to dictate how they hold their officers accountable. It's kind of asinine to say, you know, if an officer gets in trouble, another officer is going to be there to oversee what they're doing and make sure that things are right. As you know, in Charlottesville, that didn't happen in one case. They went through IA, and then IA passed the buck, and then, you know, they found out there was a mishap somewhere, and then that officer had to go to court. So I think this is a really good opportunity to have a strong oversight board. I'm not going to call it a civilian review board anymore, because then a lot of folks are going to use that as why we should have a review board. But we really need the oversight board. So I suggest also that you change your name to the Charlottesville Oversight Board, so folks won't get it twisted about being a review board. I thank y'all so much, and I really appreciate all the GSD y'all have been doing in the last 18 months. Thank y'all so much.
If there's anyone else who'd like to address the board, please click the raise hand icon. I don't see any additional hands.
You just respond very quickly to Mr. Foley without giving away anything that's privileged, and that is that the new draft of the ordinance does in fact refer to the oversight board rather than the review board.
Very well. Given that there are no more hands, I did receive word from Ms. Robinson that our special meeting has been noticed, so that's been taken care of. And if there are no other comments or questions, is there a motion to adjourn?
So move.
Is there a second?
Second.
Ms. Robinson?
Mr. Brown?
Yes.
Ms. Carpenter?
Yes.
Dr. Frazier?
Yes.
Ms. Gilmore?
Yes.
And Mr. Mendez?
Yes.
Very well. Thank you, everyone.
And thank you, Michael, and thank you, Cynthia.
Certainly. Good night, all.
Good night.
Thanks,
Bye-bye.
everyone. Good night. See you next Wednesday.